Okay, we are on live.
Hello, welcome to the Human Rights session of TUİÇ Student Congress. I am Umutcan Tarcana and I will be moderating this session. Here we have some inspiring studies that are both interdisciplinary and emphasize on the issue of human rights with recent cases. So you can ask your questions from the chat box on our YouTube broadcast. And I think we can begin with Eray Mutlu, whose study is called Minority Rights of Communist Bulgaria during Dimitrov and Cherenkov Rule, 1946-1954. Eray, if you're ready, you can just share your screen. Eray, we can't hear you right now. Can you check out your microphone? Still not. No.
All right.
Yes, it's fine now. Okay.
I guess I have to continue without microphone and a headphone.
Okay, if it's okay for you, your voice is fine now.
No, not a problem.
Okay.
It's where were we? Turkish existence in Bulgaria can be tracked by early 14th century. With the occupation of Ottomans, various Turkic and Muslim groups settled and migrated the area and established villages around meadows, rivers, and fertile lands. According to 1881 Bulgarian census, almost 500,000 Turks were living in Bulgarian kingdom and they were consisting 26% of total population. Today, this percentage is diminished as 8% of the total population of Bulgaria, and such a tremendous change of population is very interesting. However, it's not possible to cover 140 years of history in one research, so that I narrowed the scope of my research with focusing the early years of socialist Bulgaria and the Turkish minority group. The aim of this project is understanding the socioeconomic status and minority rights of Turkish minority during the George Dimitrov and Andrei Cherenkov's rule of the People's Republic of Bulgaria with the content analysis method. The project is about to commence a debate about how 1946 Dimitrov Constitution affected the Turkish minority in Bulgaria and how did newly formed communist rule handle the minority rights in Constitution. In order to achieve that, I had to search on Marxist literature and find documents about minority issue and nationalism debate. I also had to examine the 1944 coup and understand the communist rule of Bulgaria. I had to research about Turkish minority schools and their curriculums was another matter. Also, I inspected the status of Islam and the muftis. And I also translated the 1946 constitution and examined it on the minority and civilian rights perspective. Early communist writers such as Karl Marx, Engels, Vladimir Ilyich Lenin, and Rosa Luxemburg had broad debates and impressive opinions about nationalism. However, this point shouldn't be left behind. All of these writers were mainly focusing on Eastern question and Polish question, because at that time, these two main questions were dominating the political and nationalist movements field. Also, Lenin noted that even self-determination was a democratic right. Polish nationalism is something unnecessary, because Russian workers have class consciousness and a revolution was at the doorstep. So that Polish separatism will only divide the joint struggle against bourgeoisie and capitalism. But at the other hand, Lenin believes that every nation has a right to determine its future. Other means decolonization. Nation states sometimes accepts only one ethnic group as national inhabitants, thus true citizens. With this understanding, ethnic minorities are excluded from the bureaucracy, followed by expulsion of their society. The 1990 Croat constitution is one of the most significant and recent examples of this kind of constitutional nationalism. In this constitution, Croatians assumed as sole rightful citizens of the newly formed Croatian state, and constitution neglected Serbian minority. It must be underlined that Serbians were consisting 13% of the population of Croatia. About Bulgarian constitutional nationalism, Croatian kind of constitutional nationalism never implied by Bulgarian governments. They always had to respect Turkish minorities' rights and their existence. However, it's not deriving from the goodwill of Bulgarians or Turks. It was deriving from bilateral and multilateral treaties and the Turkish minorities' competitive population advantage. Therefore, Bulgarian governments were mostly favored migration movements. Turkish communities' religious and literacy rights had always under the protection of bilateral and multilateral treaties between Bulgaria and other guarantor states. Even in 1878 Berlin Congress and its descendant Tırnava Constitution provided religious freedom and gave private school status to Turkish minority schools. However, during the Tsar Boris and its personal dictatorship period, these schools were closed. When the Fatherland Front took the reign and established communist rule over the country, which it happened in 1944, Turkish minority began to organize meetings and they demanded the restoration of their old educational and religious freedom, which was taken by the Tsar Boris. Hence, on 27th and 28th of December 1944, Fatherland Front committees of the Turks in Bulgaria held Turkish minority conference in Sofia, and they demanded their old rights. 200 Turkish delegates attended this conference from all over Bulgaria. Their demands may be grouped in three sections. Firstly, problems related to education. Secondly, problems related to pious foundations. And thirdly, religious issues. These demands listed as 28 articles, and most comprehensive part of them was educational matters with 60 articles. As summarizing the educational matters, Turkish minority demanded the compulsory education for both Turkish boys and girls, lectures in mother tongue, Turkish directors for Turkish schools, retirement rights for Turkish teachers and school staff, right to admit a higher educational institution, Turkish lectures in new Latin alphabet, 1 hour per week of religious education, opening new teachers training schools, and most importantly, they demanded their old school buildings, school fields, and all property which expropriated from Turkish minority during the Zvana government and Tsar Boris's reign. According to the Turkish minorities' demands in 1944, a new constitution established and introduced in late 1946. 46 constitution was based on 1936 Stalin constitution. Despite many promises and endeavors in order to achieve socialism and equality among all ethnic entities among Bulgarian soil, nationalist policies and dreams did not fade away, and these nationalistic instincts led to first massive Turkish migration towards Turkey from communist Bulgaria, which it occurred in 1950 and 51. So that in October 7, 1950, Turkey and Bulgaria signed a migration treaty, and according to this treaty, approximately 150,000 Turkish nationals migrated to Turkey. Immigrants had to leave their lands, properties, and farm animals in order to migrate to Turkey. In this table, you can see the population graph of Turkish minority in Bulgaria, and you can see a remarkable down in Turkish popularity between 1946 and 1956. And here are the sources and references of my paper and my research. And if you have any further questions, don't hesitate to ask directly. Thank you for listening.
Thank you, Eray, for this wonderful study. As I'm personally interested in the theoretical part about the constitutional Marxism.
Constitutional nationalism and Marxist opinion about nationalism.
And it was interesting to see an implementation of Marxist theory to the praxis by the Bulgarian government. I'm just hiding my questions to the end, but congratulations for having such a remarkable study.
Thank you.
So we go on with Nikola Majkovic with his work called "In Fear We Trust: The Role of Legislative, Executive, and Judicial Powers in 2020 and 2021 Protests in Serbia and Slovenia." Nikola, whenever you're ready.
It's a bit longer title. So hi everyone. Thank you for this opportunity to present my final assignment, actual master thesis from the master program. I'm a student of the master program dealing with human rights and democracy in Southeast Europe. And as such, this thesis is related to what are the main objectives of the program. So I was dealing with I'm sorry, I forgot to share the screen. Just a second. Okay. Okay, so this is the title, and yeah, so I did a comparative case study analysis aimed and focused on analyzing and examining institutional aspects of the implementation or maintaining thing known as a politics of fear. Doing so, I was trying to understand how freedom levels of society are stroked due to this politics of fear, and how it affects freedom of assembly, indirectly freedom of expression, freedom to privacy, and some other procedural rights. And at the same time dealing with the COVID effects on the restrictions that were justified because we were fighting infection disease, and in these times abolishment of basic human rights is recognized as a fair thing in a way. So the main research questions were focused on understanding the concept of separation of power. Is it still working? Is it still, do citizens have any benefits of it? So I was focused on analyzing the legislators of two countries and to what extent they support freedom from fear. How do police forces, as the main body of Ministry of Internal Affairs and of the executive bodies, how they create an environment of fear, which means of intimidation they use in order to implement this policy, and are judiciary bodies a corrective to the arbitrariness of executive power, as know that courts are our last chance to fight for more justified, for more justice society. So theoretical framework covered normative, political and legal theory. These others on the left side, they were dealing with the politics of fear, and I used their theories as a way to explain what is the politics of fear. Three of them were, let's say, most prominent names: Franz Neumann, Judith Sklar, and Guillermo Ferrero. Franz Neumann decided to explain how this relationship of obedience of citizens towards government emerged as a consequence of creating or making fear within the population. They use the fear as an arche of their political theory, and that was the way how we should analyze and perceive societies all around from the perspective of fear. Because if we are not free citizens, we are not able to make free decisions. If we are not able to make free decisions, we are not able to have a functional society in a way. And that's the reason why we have other problems such as corruption or some other things. So Judith Sklar pointed out that how state is implementing this politics of fear. She was a refugee during the World War II, and she experienced on her own, let's say, skin, how it is when physical cruelty is experienced through our own bodies, and how actually all states around the world are, when they are confronting citizens, they are using physical force in order to intimidate citizens even more, so they should be stopped from intervening in political arena. And then Guillermo Ferrero, he noticed one paradox, saying that we organize societies in order to overcome, let's say, anarchy and problems that could emerge among ourselves as citizens. But then at the same time, there is another fear that emerged in society, and that was the fear of power itself. On the other side, there are positivist theories, positive legal theories who dealt with idea what is the law and what is not the law. I thought it was important part to mention this theoretical part because I wanted to point out on untouchable relationship between law and politics and how law is actually influenced by political bodies and parties. And in that sense, we cannot say that law is objective or that law is not unbiased. One of the research problems I identified was the distinction between political fear and psychological fear. I was more focused on political fear and understanding how institutions are creating this fear within the society and how individuals are actually experiencing it was not the main goal, because then we will go to arena of psychology, and some authors claim that we should not rely that much on psychology in field of political science because of the biases that and connections of regime and research institutes that are dealing with psychological analysis, and that in that way they impact the final outcomes. And for example, for political science, psychology, like external environment is just one of the things or factors that is influencing how are we going to make our decisions. But on the other hand, psychology see external only as something that is not really important to, it's always coming from internal aspects. So and also there was another thing with separation of power. That was the structure of the whole thesis. I divided purposefully in these three bodies because all these three bodies have the biggest power in society, and we all rely in most of the constitutions around the world saying that separation of power is the most important principle that we should fight for and allow like free society. Some of the methods I was using in this thesis are mostly desk research and content analysis of different reports or publications of international and domestic organizations, NGOs, as well as national institutions like courts. For example, when I was dealing with analysis of judiciary bodies in creation of politics of fear, there is always international and domestic aspect. Yeah, I will cover that actually in the next slide. And a legal analysis, comparative legal analysis was used to understand the differences between legislation of Slovenia and Serbia, and to eventually find some differences that could explain the current political situation in Slovenia, because the new, actually he's not new anymore, the Prime Minister of Slovenia is called New Orban because of the authoritarian policies he's implementing since he came to the power. So some of the findings were categorized in three groups. So when it comes to legislation, there is a different intervention from that is seen in international conventions from domestic legislation. International conventions are defining more broadly, for example, right to peaceful assembly. And they don't have that much good mechanism of implementation of these laws, because monitoring bodies that are operating internationally, they're not really able to coerce state to change the law or to just follow it. So in domestic legislation, there were various differences, starting from, for example, the principle of authorization of protest, or giving permission to protest, or just should protest just be notified to the officials, and that's how we can make it possible. There are some legal gaps that are emerging in terms of spontaneous gathering. How do we define spontaneous gathering? Are they allowed? Are they not allowed? And then, for example, it's really interesting that Serbian legislation define responsibility in a softer way than Slovenia when it comes to the responsibility of police officers that were breaching the law, that in the cases of police brutality. So legal maximum and minimum of the threatened sentence of prison for such officials is way lower in Serbian legislation than Slovenian legislation, which might explain why the police brutality itself was way severe on the case of Serbian side, while on Slovenian side it lasts longer because these protests last longer. So police was breaching laws in a longer period, but the severeness of these breaches were not as harsh as on Serbian side. Also, when it comes to means of coercion and intimidation, Slovenian and Serbian government used from the physical force, tiding, cavalry, service dogs, also all other means that they could use. There was more than 12 or 13 means of coercion that they were legally allowed to do. On the Slovenian side, police were using water jets, while in Serbian side, police used this gas, which expired 25 years ago. So the health of the people who were in the protest were also questioned. And finally, there was a difference between the practice of European Court of the Human Rights and domestic courts. While European Court of Human Rights was more on the side of protesters whenever there were some cases in front of this court. Domestic judiciary system was not working that well, especially first level, first instance courts, both in Slovenia and Serbia. The role of appellate court in Serbia was more on the side, let's say, of citizens, because they overruled more than half of the decisions that were made by the first instance courts. And in Slovenia, constitutional court had a role of being corrective to these arbitrariness of executive powers. And finally, there is I will try to, I don't know if you see it now. I refer to Hobbes at the very end of the conclusion, stating when the law is no longer a system of rights, but a tool for retaliation by the authorities, one should no longer use the term punishment, but the hostile act of the state. And I feel that at the end, these post-war theories, although like their relevance is still big, although they were written more than 70 years ago or even more. I would say that politics of fear is still dominant way of policies, and it's making obedience of citizens being increased, which eventually doesn't allow a free society. And when citizens are afraid and threatened, they would just continue doing these patterns. So all of these others in theoretical framework were really pessimistic when it comes to how can we solve this issue of political fear. They were afraid that all socio-political institutions are coercive to some extent because of the power and the disbalance of the power on the side of the governmental institutions and on the other side of the citizens. Right now, I'm dealing with a feminist theory. I feel they're in anti-militant discourse. There could be some answers and hopes. How can we overcome this problem of fear, and how can we eventually fight or make our societies free? I'm sorry if I skip the time a bit.
No, it was all right. Thank you.
Yeah.
Great to also great to hear about such a recent event. So I have questions for both of you, but Nicola, first I begin with you because yours was the last one. I as far as I remember, these protests were results of COVID-19 restrictions in both countries. So regarding your interest in legal and constitutional studies, my question would be about these restrictions that led to these protests. For instance, our Turkish constitution, the Article 13 of the Turkish constitution, requires codes to restrict rights and freedoms unless there's an official state of emergency. So you have to bring a code to the parliament and make it accepted to restrict any rights or freedoms officially. However, Turkish state brought these restrictions, such as travel bans, lockdowns, mask rules. They brought these with circulars, like weaker legal tests, which are not even a part of the hierarchy of norms. Was this the same in Serbia, for instance, or Slovenia? Did the state watch out for the constitutional requirements?
In Slovenia state, constitutional court had really big role in Slovenia because the prime minister, as you said, they were making new rules only on the basis of these circulars. They never passed legislative procedure. So eventually constitutional court ruled that all these rules that were promulgated before and all these verdicts or court decisions that were based on these rules are overruled. So in that sense, there is I would say that separation of powers eventually worked, because I feel that Slovenia has way stronger institutions, less corrupted than the case in Serbia. In Serbia, there were not such proceedings before the constitutional court. And also, for example, when the state of emergency was promulgated by the government, by the president, but not by the parliament, which is the way how it's written in our constitution that we should in Serbia follow procedure. And also, there were so many procedural mistakes in work of executive body. But I would say that in Serbia, except the civil society organization and people who work there, not that much people are interested in, let's say, examining if the rules in societies are following procedures. I would say that there is less power in this informal sector, but because institutional sector is really infected in a way, but by corruption policy and everything, and both presidents of Slovenia and Serbia, they are influencing the work of judiciary too much. They're putting a lot of pressure. They're commenting on court decisions. So that might be one of the reasons why these courts are not actually doing the best job they could do in Serbia.
Okay, thank you. So we have a different situations in Serbia and Slovenia.
Yeah.
For instance, in Turkey, there are the first degree courts, the criminal courts of peace, and they have just started to cancel penalties regarding these restrictions. But as far as I know, the Constitutional Court has not analyzed or evaluated an application regarding these yet. So I guess the Slovenian Constitutional Court is a bit faster than the one
definitely. But there was also one interesting situation in Serbian judiciary during this protest. For example, there were pretty similar cases in terms of what happened, why are people prosecuted. And some of the judges, for example, there were two judges from the misdemeanor court in Belgrade that sentenced people to prison sentence, but then the rest of the judges always ruled with the fines. So there was also inconsistency between the penalty policy of the courts, which I found really problematic because it's not good for legal safety and generally for the society. But eventually the appellate misdemeanor court. They overruled most of the cases that went to the second instance. So I would say that judiciary still has some power to fight arbitrariness of executive. It just like I feel that need to be personal will of the judge, or like political will if we speak about constitutional judges, because they are more politically involved than regular judges.
Yes, their ideological, academic and personal opinions are more effective regarding their job compared to the first degree courts.
Yeah.
in any legal state, I guess.
Yeah.
Thank you. So, Eray, I also have a question for you. As I said before, I was extremely interested in your theoretical approach. So my question would be about it. How do we place the means of production in a nationalist constitution? To be more precise, how does a socialist state regulate the means of production? Or nationalist state? I would love to hear a comparison from you. The means of production constitutionally.
To be honest, the communists are underestimated the power of nationalism. Mm-hmm. They weren't expecting the nationalist movements inside a socialist state, because according to them, they're all workers or peasants, or they're just peasants, yeah. Therefore, their nationality or their ethnicities weren't important. They were unimportant. However, with the 1960s, especially, we are seeing the socialist nationalisms, especially in Bulgaria. That's why we had 1978 migration from Bulgaria to Turkey, and the most importantly, 1989 migration, mass migration flow from Turkey to Turkey, actually, not from. The communists were mainly thinking about, especially the Tarkovsky or Rosa Luxemburg, were thinking about the Polish question, because the Polish people and the Polish part of the Russian Empire was the most industrialized part of the Russian Empire. So they were thinking that the Poles had class consciousness just as Russians had. So their separatist movements, their separatist instincts were something unnecessary, because eventually they will become communists. The revolution will come, and freedom from nationalist instincts and nation states. That's all, I guess.
Okay, so I was just reading, maybe you know Evgeny Pashukanis, which is an important legal theorist in early Soviet era, and he was, as far as I understood, he was always suspicious of nationalism, because it is a bourgeoisie ideology.
Yes.
Yeah, it declines and damages the class consciousness regarding its radical form, unitary form. But later Marxists, this historical process can be traced until Chantal Mouffe, I guess, are a bit more positive about the nationalist ideas, because it counterproduces some kind of populism, and it has the ability to keep the socialist power at the top of the state. So yes, they just start to see it as a political argument rather than something that damages the class consciousness. So I think we can see this transformation in the Bulgarian case, as far as I'm concerned.
I gotta say that the Lenin was also thinking about the self-determination as a right. Lenin was considering self-determination as a right, because according to him, if these colonies, the former colonies, gain independence, they will eventually become communist, and the revolution will be worldwide. That's why the early communist writers we're also considering self-determination as a right. However, if they are communist and if they also live in a class conscious a class conscious society, it will be unnecessary. If they are living in a capitalist society, yes, the nationalism would be something beneficial because eventually it will lead to socialist triumph.
Yes, this is extremely interesting, and the Marxist theory, I think, is keeping up with its evolution.
Also, I may suggest you a few more readings. For instance, you gotta check on "Break Up Britain" by Tom Nairn.
Okay, I'm just noting it out. Thank you. Because I'm a bit critical about Marxist literature because it has not it does not have enough resources regarding the studies of nationalism and identity politics. Maybe it developed a bit after 1960s with the help of post-colonialism, but not. I think it's not enough.
mostly Western Marxists are studying and thinking about nationalism, not Soviet Marxists.
Mm-hmm.
Because Soviet Marxists were already living in a socialist country, and they were living in also federal country. So in their world, in their small limited world, the nationalism and nationality identity is something unnecessary. They weren't thinking about nationalism. Most of the former Soviet citizens met with their identities after the breakup of the Soviet Union.
And I think being the representatives of the official ideology is also efficient in such a conservative attitude. And for instance, Gramsci was a radical nationalist in his earlier ages. So we see, as you said, we see more instances in Western Marxism rather than Soviet Marxism regarding the evolutionary approach on nationalist ideas. So thank you both for your contributions to our Congress. Both were wonderful works. It was so interesting to hear about such recent issues, such theoretical arguments. We hope to see you in our further studies, further organizations. It was a pleasure for me. Thank you. Hope to see you soon again.
Thank you.